Welcome to everyone on this July 5th. Welcome back to the office or back to work from the long weekend. We hope you had a great and productive 4th of July. So today we are going to go through a number of topics that we feel are interesting to you, a couple of Supreme Court cases and the implications from those cases. And then I'm going to give a presentation on absenteeism, because we've been seeing quite a bit of issues arising from our clients dealing with absenteeism, particularly in the post-COVID era. So let's get started. Next slide, Kathy. Thank you. So as I like to do, here is the most recent COVID data for New York. You see that we have seen a spike in the last 14 days of approximately 21%. Case numbers are going up a little bit. However, they tend to be leveling off a little in comparison with what we were seeing about a month or two ago. So the numbers aren't great, but they're not bad either. Next slide, please. We are seeing an increase in positivity rates, which I wanted to highlight, particularly down in the southern part of the state. You can see that northern central New York, we're seeing light yellow, light orange, which is good. But in the southern part of the state, New York City and the surrounding areas, the positivity rates are going up, case numbers are going up. So that's something that I know that the State Department of Health is keeping its eye on. Again, no policy changes to date. We haven't seen any new restrictions in several months, and hopefully we don't see any of those soon. We will obviously keep our eyes on it to figure out or let you know as soon as anything changes in that regard. Next slide, please. Okay, so next up we have Pat Malfi. Pat is a member here in our Labor and Employment Department. Pat is a very experienced labor attorney who handles all kinds of issues for clients, both unionized and non-unionized. Pat's going to give us an update on a couple of recent Supreme Court cases and their impact on mandatory arbitration agreements. So, Pat, welcome, and take it away.
Thanks, Adam, and welcome back from the holiday weekend, everyone. This topic could be a little dry because it's about the federal court's jurisdiction under the Federal Arbitration Act. But it has some significant impact on anybody who's either has a mandatory arbitration program for their non-union employees or is considering it. And when I talk about mandatory arbitration, just so we're all on the same page, I think maybe the best way to start this is assume you own a trucking company and you've got 10 drivers and they go all over the country delivering stuff. And you've got 200 people in the warehouse who are loading and unloading trucks. And all of those 210 employees have signed an individual arbitration agreement, meaning I, employee X, agree that I will go to arbitration and not court if I ever want to sue you. So let's assume that Jimmy, the warehouse guy, wants to sue you and he has sued you under the Americans with Disabilities Act. So let's go to the next slide. This is to get and to force an employee to arbitrate his claims. Most times you have to go to federal court and ask the court to stay whatever litigation is out there and to force that employee to go to arbitration and not go to court. Most times the jurisdictional basis for you to do that is the Federal Arbitration Act. And the Federal Arbitration Act is not like most federal laws. It fits on 2 pages. It's actually very, very small. And you can do that. You can go to federal court and say, Your Honor, Jimmy should be forced to arbitrate his ADA claims. Now, if you have this, what happens when you and Jimmy actually arbitrate the case and you lose, or you think the arbitrator did something wrong, or the arbitrator committed some kind of fraud? So the Supreme Court gets a case where it's considering what types of claims can get into federal court under the Federal Arbitration Act. So because Section 4 of the Arbitration Act allows an employer to compel arbitration. Most federal courts assumed that you could also have jurisdiction to either vacate an arbitration award, modify an arbitration award, or confirm an arbitration award. And this Supreme Court said no. Basically, the reason it said no, you can't move to vacate, modify, or confirm an arbitration award based on the strict construction of what the Federal Arbitration Act says. There are 3 words missing in 3 sections of the Federal Arbitration Act, which means you cannot force, or you cannot go to federal court and ask a court to vacate an arbitration award under the Federal Arbitration Act. Now, what this really means is, for anybody who has a mandatory arbitration program, yeah, you can get your employee and you can force that employee to arbitrate. But if you lose, or if you don't like what the arbitrator did, you can't go to federal court and have that decision unwound. It takes a lot of the comfort that a lot of employers felt who have mandatory arbitration programs. They wanted to go to federal court to vacate, enforce, or confirm. And this case says, no, you can't. So it's a very strange and anomalous condition where you can get to federal court and force Jimmy to arbitrate. But if you lose, you can't go back to federal court and ask the court to unwind it. Next slide. The next case is about Southwest Airlines. And let's go back to the company that you own. In the Federal Arbitration Act, there is this line. The FAA does not apply to seamen, railroad employees, and any other class of workers engaged in foreign or interstate commerce. The plaintiff in the Saxon case worked on a ramp at Midway Airport, and she physically loaded and unloaded cargo planes. And one of the stats in the case that is very interesting is the amount of cargo that Southwest actually moves around the country in a given year is more than 300 million pounds. They have an awful lot of employees who are just loading and unloading planes. So the issue in Saxon was, what is an employee who is engaged in foreign or interstate commerce? And this is the test. The test is that employee to be exempt. Now, again, what we're talking about is an exemption. So if you are a class of employee who's engaged in interstate commerce, any arbitration agreement that you signed with your employer is not enforceable under the Federal Arbitration Act. So go back to my original example. If you've got 10 drivers who move stuff all over the country, they are obviously engaged in interstate commerce. But what about the 200 people who never leave the warehouse and all they do is load trucks? And this is what Southwest said. Go to the next slide, please. Southwest said, in order to fit this exemption, you have to fly with the cargo. You either have to be the pilot or somebody on the plane while that cargo is crossing state lines. The plaintiff's argument was, it doesn't have to be that. It can be anybody who does anything that anybody ever did at an airline. And the court said both of these tests are too large. It's not everybody at the airline, and it's not only those who fly the plane. The problem with this is what they said with the ramp supervisors, they are exempt under the FAA. They are a transportation worker. So what that means is Southwest, everybody who is in a ramp who are loaded or unloaded cargo for Southwest, their arbitration agreement with their employer was unenforceable under the FAA. It's a big problem if you're running a large mandatory arbitration scheme. So go back to my original example, if you've got 200 people in your warehouse that you thought signed a arbitration agreement, the Saxon case says they're exempt and it's unenforceable under the FAA. Possible that agreement could be enforceable under state law. There are a lot of states that have parallel arbitration acts. A lot of them also incorporate the same exclusion. So it takes away, these two cases together take away, in some respects, the attractiveness of having a mandatory arbitration program for your non-union employees. Both of these Supreme Court cases, as we've seen with this court, they are really strict constructionists. If it's not in the statute, they're probably not going to, go that way. And it unwinds an awful lot of nationwide employers' belief that they had a program for mandatory arbitration that they could rely on. If you're Southwest, everybody who loads your planes, that arbitration agreement's unenforceable. What the court did, I think, that made everybody's life a little difficult is it didn't really tell everybody who is or who is not a transportation worker. I can understand the pilot is, I can understand that people who load the plane are, but what about the people who clean the plane? Don't know. And then they didn't really give us a whole lot of insight as to which way they were going. So you're going to see the scope of this exemption. There'll be an awful lot of cases in federal court arguing about who is or is not a transportation worker. And there's one last case. Next slide. Okay, it's interesting. I'm not going to spend too much time with it. In California, there is a type of class action which is just monumentally annoying. It's called the Private Attorney General's Act, which means that an employee can actually stand in the shoes of the Attorney General and prosecute a case. It's got all kinds of excessive penalties to it. It's a cottage industry for class action lawyers. And what is surprising is California state court said that those PAGA claims could not be subject to mandatory arbitration. In a strange twist, this Supreme Court said, no, they can be. They can be forced to individual arbitration. And what you're seeing is the court basically a little bit expanding the scope of what could be subject to arbitration, while Congress in a lot of the states are going the other way. You've got the recent federal legislation that sexual assault and harassment cases can't be forced to pre-dispute arbitration clauses. New York and California, Jersey, several states have gone along those lines trying to restrict the use of mandatory arbitration. This court is signaling that they will enforce those agreements if and when they ever get to federal court. The problem is that they've, with the first decision, taken the amount of cases that have jurisdiction under the FAA and probably sliced it in half. So it was a very interesting term thus far with the Supreme Court and the Federal Arbitration Act. That's it.
Thank you, Pat. That is very informative. If anybody has any questions about their individual employee mandatory arbitration program, feel free to reach out to Pat and he will be sure to guide you in the right direction. Thank you, Pat. We really appreciate it.
Thanks, everyone.
Okay, next up is DJ Nugent. You've seen DJ on the webinar before many times talking employee benefits. So DJ is here to do that again today in a very specific context. We've seen the reports of a lot of companies providing incentives, or not incentives, but reimbursement for certain activities following Dobbs decision. So DJ is here to talk to us about Dobbs and its very, very specific implications in the employee benefits world. So DJ, welcome. Thanks for being on again.
Thanks, Adam. And like Adam said, this is a very specific issue following Dobbs, just with respect to employee benefits. And I'm going to speak on a very high generalized level. There are a lot of issues at play and a lot of considerations. So this is not by any means an exhaustive summary or overview, but just some of the really big picture items that some employers may want to consider. Next slide, please, Kathy. So like I said, I'm sure many of you on the webinar have seen in the news that in light of Dobbs, some employers are responding to that decision by either announcing that they're going to make certain benefits available or that they're considering making certain benefits available to employees in states in which abortion is now illegal or anticipated to become illegal, to assist employees in that state in obtaining abortion-related care in a state that it is permissible or legal to receive that care in. any employer who is considering providing those benefits, there are many considerations that they want to take into effect. But I just wanted to write kind of the big picture issues that any employer in that instance would want to consider. The first, in my mind, is whether the employer's group health plan is self-funded or fully insured. Fully insured group health plans are subject to state insurance law. So what that would mean is if the state insurance law in a state in which abortion is now illegal is amended to state that also insurers cannot provide coverage for any abortion-related services, those fully insured benefits would not be able to be provided using a fully insured product. Self-funded group health plans, on the other hand, are not subject to state insurance law. State insurance law is preempted by ERISA for those self-funded group health plans, subject to a potential very important caveat that I'll get to in a minute. So self-funded group health plans, regardless of what the state insurance law says, again, subject to one important caveat, would be able to provide abortion-related care in a state in which such care is legal. So if you're in a state where abortion is prohibited and in which the state insurance law also says insurers cannot provide coverage for abortion-related care, but you're a self-funded group health plan, your plan can provide coverage for those benefits in a state in which it is legal, or it can provide other travel and expense reimbursements for those benefits to obtain care in a state in which it is legal. The other potential option that's available is even if you have a fully insured group health plan in a state in which the insurance law states that fully insured plans cannot provide that coverage, would be to offer a self-funded benefit that's integrated with the fully insured plan. And I think there's an argument to say that that self-funded benefit would not then become subject to that state insurance law. But again, you really need to understand what the insurance laws are at issue. So after you've determined whether you have a self-funded benefit or a fully insured benefit, you need to look at the applicable state law, like I mentioned before. Does your state insurance law, is it silent on providing abortion-related care, or does it explicitly prohibit you from doing so? The caveat that I mentioned before with respect to self-funded plans that would generally be exempted from those state insurance laws are generally applicable criminal laws. I'm sure everyone on the webinar has seen that states such as Texas and Oklahoma, and likely several others, have introduced these laws that are commonly referred to as aider and abettor laws. Essentially, even insurance plans that provide their employees with benefits to obtain abortion-related services in a state in which those services are legal could have potential civil or criminal liability. It's questionable whether those laws will be preempted by ERISA. So in ERISA preemption analysis, there are several cases that we can look to help determine that. However, I'm not aware of any case in which these types of criminal and civil laws have been tested before. If you read the news, it's very likely that these cases will be brought to test the potential ERISA preemption of those aider and abettor statutes. So if you have employees in a state in which those aider and abettor statutes exist, and even if you're self-funded, you need to consider what the potential ramifications are of providing those benefits, and kind of wait and in my mind, it's a wait and see approach to see how those challenges to those laws shake out. So after an employer who's considering making these benefits available to employees considers whether it's self-funded or fully insured and any applicable state law, including the aider and abettor statutes, if the employer still thinks it's possible to offer benefits and still wants to move forward with doing so, the next consideration is what are the applicable benefits and tax legal requirements that would be applicable to any benefit that's offered. Does ERISA apply? Does the ACA apply? Does the Mental Health Parity and Addiction Equity Act apply to the benefit that's being offered? What are the tax consequences? If the benefit is being offered on a pre-tax benefit, are there limits on the benefits that can be offered? Do you need to make sure you're not discriminating in favor of highly compensated employees and would risk negative tax consequences if you are? Again, these are very general, non-exhaustive considerations, but definitely things that would need to be considered. After an employer who wants to offer these benefits goes through that consideration, I think the next step is how is it going to be administered? If you have a fully insured benefit and you think there's a fully insured product that you can offer, how is the insurer going to administer that as part of your plan? In contrast, if you're a self-funded plan and you want to make a self-funded benefit available, is your third-party administrator going to be able to administer that benefit? If not, do you have the capability to administer that benefit? So just because it's legally permissible and you can design your benefit in a compliant manner, the practicality of administering the benefit definitely needs to be taken into consideration to make sure that you stay in compliance as you administer those benefits. So after you've considered all of those considerations, I think the last step is these are all kind of thought of at the same time. What benefits do I want to offer? Again, if I'm a self-funded plan, do I want to amend my self-funded group health plan to provide coverage for abortion-related services in a state in which it's legal? If not, if I'm a fully insured group health plan that's subject to a state insurance law that prohibits the fully insured plan from providing coverage for such benefits, is there a self-funded arrangement that I could enter into to make those benefits possible? Conversely, do I want to just provide travel and expense reimbursements for employees who travel to a state in which it's legal to obtain an abortion to have some of those costs reimbursed? Do I want to do this on a pre-tax basis, or would I rather just do it on a post-tax basis? If on a post-tax basis, you need to make sure you're not running afoul of any of the ACA's employer-provided plan rules. So I know I threw a lot of information at everyone there, just very, very high level, some of the big picture concerns that anybody who would want to enter into one of these arrangements should want to consider. Definitely good to speak with third-party administrators and counsel if you're an employer who is considering offering some of these benefits.
DJ, thank you so much. And I would highlight that last piece. There are clearly a lot of layers to this decision that may have implications beyond what your intention is. So make sure you are consulting with counsel before you put a plan such as this in place. You can contact DJ, you can contact anybody in our employee benefits group, and they would be happy to help you. So DJ, thank you so much. Always a pleasure to have you on.
Thanks, Adam.
Okay, so next up, what I wanted to do was tackle an issue that I have seen multiple times over the last couple of months. And, sometimes your survey responses trigger a topic on this webinar, but sometimes our practice triggers a topic on this webinar. And I can tell you that I've had a number of clients call with virtually the exact same question in the last couple of months. So today, that's what I'm going to talk about, and that is post-COVID absenteeism issues. Next slide, please. And I want to frame this discussion with a hypothetical. So we have John Jones. John started working for XYZ Corp 3 weeks ago. He's already called in 6 times claiming he's sick. Last week alone, he calls in 3 times because he was experiencing COVID-like symptoms. You are the HR manager for XYZ Corp, and you want to think about, what can I do? This is completely ridiculous. We've only hired John 3 weeks ago. He's only been here for 3 weeks and he keeps calling in sick. So what can I do? So what I want to do is walk through the various steps of this analysis and how you could proceed to answer your question. Next slide, please. So we're going to look really at 3 things. We're going to look at the handbook, your existing employee handbook, and what it says. We're going to go through the various statutory concerns to see if we have anything we have to address. And then how are we going to handle these issues? What is the process going to look like? Next slide, please. So let's start with the handbook. More likely than not, your employee handbook is going to have provisions relating to either attendance, a probationary period, sick leave, PTO, or all of the above. So what you want to do is, you've hired John, you've given him the handbook, you want to make sure you familiarize yourself with exactly what the handbook says regarding absenteeism. So is there a probationary period within which you say newly hired employees have to engage in whatever conduct during the probationary period, or risk termination. Now, there might be a statutory concern that prevents you from enforcing that in this case, but we'll talk about that in a minute. You want to make sure you understand your policies. With respect to your sick leave policy, remember, you have New York's paid sick leave law. Are you front loading your leave, or are you having your employees accrue it? Because if you front load your leave and you give everyone right off the bat the full number of hours that you're required to under the paid sick leave law, then you may have to provide that leave to John, and you can't do anything about it if he hasn't exhausted it. Even if he hasn't earned it, if you front loaded it, he is taking leave that he is entitled to take. With respect to PTO, how is PTO accrued? When is it accrued? Again, is that front loaded? So make sure you understand your policies and what your policies say. That's going to be step number one. Next slide. All right, so step number two is let's work through the various statutes that may present a problem for you, or not a problem for you, but may direct how you respond to John's issue. So first of all, the FMLA. We know I've listed out very high level what are the eligibility criteria for FMLA leave. John's not going to qualify for FMLA leave because he's only been there for 3 weeks. So I give you this summary in the slides, but in our situation, in our hypothetical, FMLA is not going to be an issue because John wouldn't have satisfied the eligibility criteria. Next slide, please. So again, when you're downloading our slides, I've put this up here so that you can have it. These are the various bases for leave under the FMLA. You know, if John were to be eligible, he may qualify if he met the definition of having a serious health condition that made him unable to do his job. Next slide. And here's what benefits are available under the FMLA. Again, up to 12 weeks of unpaid job protected leave, no retaliation, and it doesn't have to be taken in one block, can be taken intermittently. Next slide. Okay, so the next statutory concern, which is a real one in this case, is the Americans with Disabilities Act. To be eligible for benefits under the ADA, an employer has to provide, just a general statement of what the ADA requires. An employer has to provide a reasonable accommodation to qualified individuals with disabilities who are employees or applicants for employment, unless to do so would cause undue hardship. And here I'm going to point something out. It's actually from a recent case that was filed by the EEOC. And when I say recent, I think it was in the last couple of years. Essentially, you had an individual who was hired by a company. The individual went out sick within the first couple of months of being employed, and he was terminated. The employee filed a claim under the claim with the EEOC. The EEOC then decided to sue the employer on the employee's behalf. And I think what the message of the case is that there is no waiting period under the ADA. So unlike the FMLA, which in order to be eligible for leave under the FMLA, you have to work for a specified period of time. The ADA does not include a probationary period like that. So someone who you hire is going to be entitled to the protections of the ADA from day one. So that's something to keep in mind in John's scenario. John, although he just got hired, is protected by the ADA. Next slide, please. So who is an individual with a disability under the statute? It's someone who has a physical or mental impairment that substantially limits one or more of his major life activities. I've underlined those terms because they are defined terms under the statute. I'm not going to spend the time to go through that with you all today because our time is limited, but this is how the statute defines an individual with a disability. It's also someone who has a record of such impairment or someone who is regarded or perceived as having such an impairment. So that is someone who is disabled under the ADA who would be entitled to a reasonable accommodation. Next slide, please. You, as an employer under the Americans with Disabilities Act, have an obligation to reasonably accommodate the known physical or mental limitations of a qualified applicant or employee as a means of overcoming unnecessary barriers that prevent, and I'm not going to read the rest of it, but essentially your obligation is to reasonably accommodate disabilities that you knew or should have known about, unless those accommodations would pose an undue hardship. Next slide, please. So in John's case, there is an obligation, it seems, that would probably be triggered from his repeated absences to start off this interactive process. I'm sure all of you know what the interactive process is. It is the dialogue between employer and employee about the disability, about accommodations. So the ADA requires an interactive process where you can work together with your employees to determine whether or not you can reasonably accommodate their disability. Here is the important point that I want to make in John's case, is that you can ask for documentation if the disability or need for accommodation is not obvious. This is a very difficult concept that puts employers in a very difficult position because you are limited in inquiries that you can make by the ADA. So there is limiting language about what you can ask for and when, but at the same time, you do need to understand the disability and you do need to understand the accommodation that is being requested. So the ADA allows you to require documentation that is needed to establish that the individual has a disability and that the disability requires an accommodation. One thing I'll point out here is that the ADA does not allow you to just get your employee's entire medical file. Your request has to be very narrowly tailored to the specific disability that you're dealing with and the accommodation that's being requested. It is helpful for employers to have an ADA request form available for you to provide to your employees that they can fill out to let you know about the information or provide you with the information that you need. That can also include medical documentation that is filled out or completed by their medical provider. Next slide, please. So before we move on to the New York Human Rights Law, I just want to say that in John's case, the ADA is definitely implicated, and it's something we may want to explore. I'll address that last. Okay, so next statute that we're concerned about is the New York Human Rights Law. Similar to the ADA, the New York Human Rights Law requires accommodations of disabilities or specifically enumerated pregnancy-related conditions. I will say this, and I've encountered this in a number of cases. The New York State Human Rights Law has a much broader definition of disability than the ADA. The ADA requires that the medical condition substantially limit major life activities. The New York Human Rights Law does not include that restriction. So the definition of disability is broader and can encompass more conditions than the ADA. There is also a very specific regulation in the New York Human Rights Law regulations about accommodating temporary disabilities. So this may be something that would be implicated in John's case. Is this a temporary condition? Again, you need more information, but the New York Human Rights Law and its duty to accommodate may be implicated. Next slide, please. So believe it or not, the New York COVID leave law is still around, and it is still something that you need to consider in this case. So very briefly, I know we've talked about the New York paid COVID leave law maybe 100 times on this webinar over the past 2 years, but it is applicable to both public and private employers. It provides up to 14 days of paid leave, depending on the size of the employer. It deals with or provides leave to employees who are subject to a mandatory or precautionary order of isolation or quarantine issued by a governmental entity. There has been a lot of discussion about self-attestation forms that are being used by the state and the various local health departments relating to quarantine and isolation. We've talked about that ad nauseum on this webinar. I'm not going to go into it in detail now, but once a governmental order of isolation or quarantine is issued, then this statute becomes triggered. The leave has to be job protected, can't be charged against other leave, including sick leave, and it's the amount the worker would have otherwise received during the particular period. Importantly, and why I'm mentioning it now, is there's no expiration on the statute. So it is still valid, it is still out there, and it is still something that you have to be concerned with. Next slide, please. Just by way of review, this leave is available up to 3 times. The second and third times must be due to a positive test. And then there's also guidance on the state website, Department of Health website, that if you as the employer mandate someone to go home who's not otherwise subject to a quarantine order or isolation order, you have to pay them according to this guidance until their test is received. Next slide. Okay, so let's talk about John's case for a minute. We know that the FMLA is not going to be applicable. I say here that the COVID leave law is not applicable as well, because in John's case, he's only had symptoms and he's called in sick because of symptoms. You're not telling him to stay out. That's not your decision. And he's not subject to a quarantine or isolation order that you know of. So you'd ask, did you test positive? Are you subject to a quarantine or isolation order? He's going to say no. So the New York COVID leave law is not implicated as well. So with respect to your paid sick leave law policy, again, I mentioned that issue about front loading at the beginning of my presentation. That could pose a problem. If you front load leave for your employees, then he's going to have all that leave available, whether he's worked 1 day or 310 days. So one potential solution that I've seen employers utilize is having leave accrue under the New York paid sick leave law for the first year, and then kickstarting into front loading that second year if that's what you do for your employees. So that is a potential option. Accrue for the first year and then front load for the rest. Same thing with vacation or other PTO. If that's something you're concerned about, you could accrue for the first year and front load for the rest. So that's something you need to make sure you're understanding with respect to John's case. Is there leave available under my policy? We just talked about the ADA and the New York Human Rights Law. Those laws are definitely implicated here because leave is a potential accommodation. So there is a possible need to accommodate John's condition. Right now, you don't know anything about John's condition. So if this is something where it's not obvious and you are permitted to request information under the ADA, then you need to gather more information. You need to understand, is there something that is causing John to be absent so frequently within such a short period of time where leave or some other accommodation might be appropriate? Make sure you engage in that analysis before you take any action. That would be my main message to you today. Make sure you're going through and gathering information before you decide, well, John's been absent all these times. It's been a short period of time. We're just going to fire him. You may run into a problem. We have seen the New York State Division of Human Rights take the position that disciplinary action without investigation, particularly in a situation like this, may lead to a claim under the human rights law. So I would provide a word of caution. If you have questions about what is the appropriate action in a specific circumstance, don't hesitate to reach out. We work out these issues for clients all the time. But what I wanted to provide to you was a nice little checklist that you can work through if you encounter any of these issues related to absenteeism, particularly in a post-COVID world. So thank you. We're going to wrap up just a little bit early today. Great to be with you all. If you have any questions about the topics, here are the presenters' contact information. I will plug the book that we have on New York State human rights or New York State labor law, labor and employment law. Very thorough summary of all the topics we discuss on these webinars, and you can access them there. So great to see you all. We hope to see you next week. Have a great week.